I'm going to go ahead and jump in, and I know I'm not on the agenda. I was kind of a fill-in at the last moment, and because of that, I want to make sure that I don't misintroduce anybody on the panel, so I'm just going to let them introduce themselves and tell you a little bit about them, and then we're going to switch up kind of how we wanted to do this, but I'll explain in just a minute after all the panelists introduce themselves.
Good afternoon. My name is Ed Jackson. I'm from Baltimore, Maryland. I'm the newly created Inspector General for the Baltimore Police Department. A little bit about my background. I was a career Baltimore. I was a career Baltimore police where I served for over 23 years. Before retiring in 2004 as the chief of the administrative bureau, oversaw the police academy, our legal department, procurement, and things of that nature. And after I retired, I went into academic life where I became a professor of criminal justice and sociology at a community college in Baltimore. About a year ago, the mayor of Baltimore City, upon her election, Mayor Catherine Pugh, asked me if I would serve on the Community Oversight Task Force as a part of Baltimore Police Department being involved in the consent decree. And so I served there for about 8 months until recently, about a month and a half ago, when she asked me to come out of retirement and serve in a civilian capacity as the Inspector General for the Baltimore Police Department. And some of the things I do in addition to what IGs usually do, and that's investigate waste, fraud, and abuse. I'm also doing things like centering policy around Giglio and Brady. Of course, we have over 500 paragraphs in the consent decree that we must satisfy. I'm oversee policy, and as soon as we get staff, we hope to do some forensic auditing, and I'll let my colleagues, who I'll introduce real quickly, talk about that. Also, we have use of force investigation. We call it the acronym is CERT, and that acronym stands for Special Investigation Response Team, and we investigate any injury that results from a police action up till death. We investigate deaths, homicides, and serious injury involving police. And also we have a use of force assessment, performance review board. And what we do is we analyze actions taken by Baltimore police for the purpose of revamping policy should we see gaps in in our current policy. And then lastly, one of the things that Commissioner Darrell D'Souza asked me to do is look into constitutional based and impartial policing and address bias in policing. And also with me today, I have two of my very important staff members, Ian Dabrowski, who's a career policeman. He has the CERT and the PRB. In addition to being a police commander, he's also trained as an attorney. And I have James Roden, who is my deputy IG. James does many things. He's an adjunct professor at the University of Maryland University College. He's most recently been a commander at the police academy. And upon his promotion about a month and a half ago, he became my deputy IG. So that's kind of like my introduction.
My name is Tracey Kavanagh. I've been in the Philadelphia DA's office for the past 30 years. I started out in the trial division. I was in the trial division for about 10 years. Came over to the law division. For the past 15 years, I've been in the Post-Conviction Relief Act unit. I work closely with Patricia on my cases when there's claims of innocence or illegal sentences or just not unfair sentences. I also work closely with Brad Bridge with the police corruption cases. I've been doing that since January. Just last week we agreed on about 75 cases that I know prossed involving a police officer who had admitted that he was lying in court to protect his confidential informant. Brad and I are, on a daily basis talking and trying to work out cases in all different categories of the police corruption cases. And I work again with Patricia on those cases too, figuring out policy, figuring out how to which cases to agree to, which cases to agree to expand with Brad. So that's it.
Good afternoon. My name is Dave LeBlanc. I'm the president of the Association of Prosecuting Attorneys. We're a national association out of D.C., primarily the larger offices when you look across, the New Yorks, the L.A.s, and such. I came to this job, I've had a 10-10 and now an 11 career, so hopefully sometime I'll be able to retire. But I think like your assistant inspector general, you've got 2 in college, right? Yeah, I do too, so I've got to keep working a little bit. And my law school looked just like this, as we were saying earlier. I don't know where Steve's at, the room there and the food. This is just like when I went to law school in the 80s. It hasn't changed at all. But tuition, I think, helps, doesn't it? But back on task here. I spent 10 years as a trial prosecutor in 2 very, very different counties in California. As Barry talked about, my origins is out of California. I started in Orange County, California, until it went bankrupt. For a lot of the discussions today, during the bad 90s, I was assigned to the Westminster Police Department. So I worked directly as a prosecutor. I was one of the prosecutors assigned into the department. As we talk now about research and testing, I didn't know it was unusual to not have a research partner with me. Someone from Claremont University, are we making a difference? Can we drive down the violence? But as it talks about relations with law enforcement, very interesting to get dropped into a department behind the blue line and see the inner workings. To me, it raised the professionalism. I didn't see anything of what we talked about today, but I'm digressing. Orange goes bankrupt. Another of our discussions today is things like crime labs. Try working for a county, try being a senior assistant with a county that's bankrupt, with the crime lab run by the sheriff's office, that they're also bankrupt. How are you going to properly process cases, especially when that was a lab that was pioneering on a lot of the things like the DNA work. I thought after being behind the orange curtain, time to go behind the emerald curtain. Up to Humboldt County, very, very different jurisdiction, one of the smaller counties. It made below the fold of the post because it's the world of green dope. And so you roll up there, the marijuana production is the cash crop for the community, and a lot of the discussions about what you do with cases, just because someone grew some dope to try to put braces on their kids, is that really criminal? So as a prosecutor, you kind of work through those sort of things. But what my work there was, again, with the community law enforcement and others, because of the child deaths, it was really looking there and say, what can we do better as far as everybody coming together with the kids that were killed, even a lot of the discussion here about placement of kids. From there, I had such a good time in Humboldt, off to Sacramento. I ran the California DA's Association, so I spent 10 years representing prosecutors in Sacramento, looking very much at a lot of the policy issues. I think that's why Barry picked on me on the Police Officers' Bill of Rights and police personnel records. Really struggled with that and worked with a great group of prosecutors. You look at the 58 counties in California, they're incredibly diverse. And like George Gascon was talked about today, San Francisco and LA have always been different than the rest of the state. But as a uniform group, how do you do and deal with criminal justice? I then jumped nationally, first over to the National District Attorneys Association, membership organization, tried to help them with some of their work, and then ultimately now with APA. So a lot of work in the policy, and very much, and on behalf of prosecutors, it's great to have a job that you really are out there looking, what's the right thing to do? What's, to the right person for the right reason, is really all we're trying to do. So, thank you. It was me. I'm doing feedback on everything. See, as prosecutors, we'll get fingerprints. I'll try it. Now she's making me sound old.
A problem solver, I love
I'm
it.
Dave, I'm not Mr.
My name's Eric Sussman. I'm the First Assistant State's Attorney for Kim Fox in Cook County, which has gained even more notoriety after sitting here today. You feel like the defense feels after the 3-week-long prosecution case where the jury is just looking at you like, seriously? That's me. In my defense, or my boss's defense, so my background is I was in private practice for 5 years, 6 years, clerk for a federal judge, then went to the U.S. Attorney's Office for about 10 years, where I did all kinds of cases, everything from guns and dope to actually we prosecuted the chief of detectives of the Chicago Police Department, who had a very elaborate jewel theft operation in his spare time. So I left the U.S. Attorney's Office. I was in private practice, very happily defending white-collar, misunderstood people. And then I actually did some pro bono cases and did have some experiences with the Cook County State's Attorney's Office, none of which were particularly favorable either on my end or theirs, I would say. And then I was asked by Kim Fox in her transition if I would be interested in coming in to take over this job. And once I heard the pay, I said, for sure, yeah, this sounds great. But in all seriousness, I came over really for the reasons that a lot of people here have concerns. I mean, I came over because Chicago had just come through Laquan McDonald. State's Attorney Fox was the reason, was sort of the aftermath of that. We had all-time highs in terms of shooting. There were serious issues with police accountability and police involvement in those shootings, and so it just seemed like a way for me to really make a difference. I don't think I understood when I came over that, as Larry talked about, that in addition to dealing with one of the larger homicide problems in the country, in addition to dealing with fiscal crisis and a system that is, someone mentioned the paper system in Cook County. I think Cook County alone keeps, if whoever makes carbon paper, that is actually still being used in Cook County. But since I've been there, we have set up a conviction integrity unit, a very robust conviction integrity unit with a terrific supervisor. We've, I haven't counted them all up, but I think probably, I know we've exonerated, however you want to define that word, over 30 people in the time we've been there. And then I will, Barbara pointed out, I figure I should also give you my bona fides with the FOP. I pulled up a recent article in the Chicago Sun-Times that attacked me personally and talked about that it was another a deplorable decision that we had a murder case actually involving one of the, we'll call one of the Guevara cases that Melissa talked about earlier. And the conviction came back because the lawyer, the defense lawyer, had actually represented Ray Guevara personally in some divorce proceedings and other things. So there was a conflict of interest. There was going to be a new suppression hearing ordered. And there were 5 Chicago police detectives who were being called to testify. All 5 of them took the Fifth Amendment, and so we dismissed the case. So according to the FOP, it was my decision not to retry Masonette, and blaming the police for my decision that was despicable, and another powerful sign of my antipathy to law enforcement. So I think that's probably sufficient introduction.
Off so we don't make that horrible noise. Let's see if this works. Okay, so far so good. So as Maurice said, you're very lucky if you're an afternoon panel because you get the ability to kind of piggyback off what other speakers have said. And we actually kind of recognized that earlier today, and we decided, given the fact that we were the last ones, we're the law enforcement component, the token folks at this conference, figured what we would do is instead of give, 10-minute speeches to you, we were going to take 4 or 5 different questions and comments we've heard throughout the day, and then give you our insight regarding that, and then open it up to you all so you can ask questions about it. And sometimes I will credit the people properly in terms of who actually made this comment, but sometimes I will not because I don't remember. Starting first with Matthew. Matthew said something that we all loved, and basically what he said earlier this morning is he said, the burden of systemic injustice should not fall on its victims. We all like that. And of course, the easy part of this is I'm going to ask everybody on this panel to say, do you agree or disagree? That's the easy part. And then maybe shed some light on why they have the position they do. And you guys can just kind of jump in and go in whatever you want, whatever order you want. I'm thinking you're all wanting to jump.
Well, I mean, look, intuitively, I agree with that. It sounds right. It sounds like the right thing. I think practically putting that into play is very difficult. And I mean, for someone who comes at it, it is, I will say, I know there is a lot of selection that goes into Exoneration Project and other places before they decide on taking on a client. But once you take on a client, you are there to advocate for your client, and it's not easy. I've done it, but it's also different than what we are looking at in the prosecutor's office, which is trying to do the right thing and trying to make sure justice, that we achieve justice. And there are a lot of different winds that are blowing, whether it is the media, whether it is the attorneys, whether it is something that no one has mentioned here today, which I was surprised at, whether it is the extremely lucrative civil practice that has piggybacked on many of the exonerations. And I say that only not to say that people should not be compensated for their time in jail. I mean, we actually are very clear when we deal with exonerations or deal with people who want their convictions overturned, we will not require them to waive anything. Those are separate issues, even though we, as the civil division, our civil division will actually have to represent the county and will have to represent, in some cases, some of the former or current assistant state's attorneys who may have been involved in that case. So we have to take ourselves out. That having been said, it is impossible not to recognize that there is a cottage industry that exists, particularly in some of the jails, and what that of recants and tit for tats, and that can make it very, very difficult to take things at face value. And in the same way, Larry mentioned, anyone who in this day and age takes the fact that someone confessed as, well, then they must have done it. I think as someone who is looking at these cases, and I don't think that the defense lawyers in this room are any exception, you have to look at some of the recants that you see and some of the evidence, so to speak, that's coming in after the fact, and you have to look at it critically. It doesn't mean that you think there's a big conspiracy out to get you, but it does mean you have to be cognizant of it. All of which is to say, it's a lot easier said than done. I mean, to try to, particularly in most of these cases, we're talking about 25 years later, to try to figure out, okay, what really happened? What is this person innocent, or do we have issues with the integrity of this conviction? And how do we find our way through that thicket? And so I don't want to say the burden is on people like Josh, and it shouldn't be, but to a certain extent we rely on them, and we have to go much further than just saying we have a bad police officer here, so anything that he or she touched we just have to throw out.
So first I get to answer the easy part, right? Is of course, there's not a single prosecutor out there that goes to work that wants to use their time and talent to convict an innocent person. That's just ludicrous. I've never been in an office where folks are like, wow, this is, we've got someone that didn't do anything, we really want to get a conviction. That's a non-starter. The question instead is, what were the mistakes? How did it happen? Even the name of this conference, some of the struggles we had with it initially, talking about that it is purposeful, versus it's a human system. You've got a lot of moving parts and a lot of moving pieces. So I'm going to separate today's discussion into two. One is the drug cases, and say really on behalf of prosecutors, when you're told that there's a bad criminalist, we heard about Massachusetts, that she touched all these cases, it's pretty easy in those cases just to say, you know, once, and I know it took time, and I know there's a lot of things that were pointed back against the district attorneys, but that's the evidence of the case, right? The drug case, there's also been discussions about breathalyzers, DUI cases. When you're told your evidence is no good, it's pretty easy to say, all right, as a mass number, we can set those aside and just get rid of those cases. Because if they have a problem, they're going to come back. But if they don't, you know, then you know, why touch them anymore? How does that compare to one of our diversion programs? You diverted the case, they didn't do anything else, and the record's all nice and clean. When you get into the officer involved kind of area, that does raise that question. How involved was the officer? I think it's Debbie, and I hate to use the first name because you called me Mr. But you know, your discussion of looking at that videotape where the officers are kicking the blood, because in a lot of times in the prosecutor mentality, it's like that officer was not involved. That officer didn't do anything critically in that case, and so does that taint the case? Even though it smells, we know it's a dirty officer, but if they didn't do it and the victim is over here and saying this is the right person, it's really hard to say, well, because you had a dirty cop, now we're going to dump that conviction. That's that harder discussion. And I'm going to go with Eric because that is the challenge with a lot of offices right now, that you've got a 25-year-old case. Somebody's already served 25 years. If they were convicted today, would they serve 25 on it? Maybe, maybe not. And so it's really hard not to just say, because of whatever reasons, we're just going to go ahead and you know, let them go. But then the ramifications of all the pieces of it, well, then you're calling the cops, you know, incompetent or they did something wrong. So there aren't many offices out there. There's about 30 with different varieties of conviction integrity, conviction and review, and pretty active, you know. But there aren't a lot of them that will just step up and just say, it just seems like in the interest of justice, let them go. And then the civil ramifications seem to pile on and cause that not to happen. Versus the things, especially on behalf of my organization, I think commutation is a much, much underused thing. And we've been involved in a number of the Georgia cases, and that's where I would have liked to know more in proportionality, but got approached. Look, this person's already served blank number of years for a small amount of drugs. Can't we just work in the process? Can't you work with the DA to get that person out? That's really been something to me. It's like that gets us to the proportionality that Larry was talking about, and gets away from the fight of an exoneration. But I've gone off track in the sense of the drug cases, the DUI cases, those are much easier for most prosecutors' offices than the crimes of violence, especially with the victim, victim's family, or other issues on the side.
Well, first of all, I do agree with the statement. However, practically speaking, for instance, in Philadelphia, there are 2,000 outstanding post-conviction petitions being actively litigated now. And in my unit, there's only 8 attorneys. At the most, we've had 12. So we get countless petitions with recantations, countless petitions with after discovered evidence. It's almost impossible for us to handle all that work on top of the corruption cases. So when an attorney takes the burden on and can, you know, help us go through these petitions and figure out which ones have merit, and then we can take a closer look at those. We have our 8 attorneys, and then, as I said, I work closely with Patricia and Andrew. But we hate to keep the burden on the defense, but once somebody comes with a colorable claim of either innocence or an unfair sentence or an unfair trial or the police corruption cases, we try to work with the attorney and maybe take some of that burden off of them and share the burden so that we can get the right result. So.
Of course, I'm not a prosecutor or a defense attorney, but I agree with the statement. I agree with the statement in a more ethical manner. I mean, you can look at it deontologically, which would argue ethically that we have a duty to right any wrongs that may have occurred as a result of the process. And then theologically speaking, that's the greatest good for the greatest number. So how do you manage this? I don't know. It's like reparations for slavery or 75 years of Jim Crow. How do you manage it? How do you go back and right every wrong? But I would say that, in agreeing with the statement, that we have the system itself, that's the prosecutors as well as the police departments and the courts, the criminal justice system, if you will, the so-called system, has an obligation, once it's discovered that there may be a problem with the case, even if the person did it, if it's not rooted in the Constitution, if they weren't afforded all of the rights and liberties and privileges afforded to the Constitution, then I think we do have an obligation. I think that's what sets us apart from many governments. We purport ourselves to be a democracy where we value individual rights, so we can't have it both ways. I think what the criminal justice system has become politically is that we put cops in a position a lot of times to do wrong, and that's another discussion. But we really subject them to things that they're not trained to address, that they're not equipped to address, nor that they create. And then when it goes bad, quite often bigger societal problems are ignored, and law enforcement becomes a scapegoat for a lot of these processes. I don't know if that answers.
And I'm just going to segue into, we've heard a little mention of Brady obligations, but there hasn't been any real kind of concrete discussion regarding that in the context of police misconduct disclosure. So kind of narrowing now the question to that, I wanted to ask you all, I think everybody, let's just assume everybody's in a jurisdiction where we say both legally and ethically you have a post-conviction obligation to disclose. First, I want to ask, do you do it? And Tracey, I'm looking at you because I'm thinking, despite the fact that you and Brad have done so much work, I dare say that I doubt the DA's office has really sent out post-conviction Brady notices in the past. So assuming that we have the obligation, is that something that you all think that we should be doing? And if we're not doing it, talk about why, and why it appears that the defense is just so much better, even though we're saying their clients ought not suffer from the injustice of the system. Why is it that we're only getting something done when they're bringing it to us rather than us trying to sort it out and fix it to begin with? So there were multi-parts to that. And Tracey, you start since I directed it at you.
Yeah, so I think, first of all, I don't think our focus as a DA's office, it's mostly been on prosecuting people. I mean, we always wanted to do the right thing, but I don't think the focus was there, and putting maybe the manpower and the money into ways to help track cases so we could do some of the things that Brad Bridge has been doing. You know, once Brad was bringing things to us, we just respond, but I think now we've been in discussions, and as well we should, about how we can help identify the cases, how we can help spread the word about the Brady materials that we're coming across, rather than us just having a list, sharing that list of problem people or information that could help a defendant. Again, as we talk about, it's not by sharing this information, we're not saying it's admissible, but at least sharing it, you know, we're going to get a fair trial. That's what we want. We want a fair trial. So we've been talking about ways that we can identify cases and ways that we can help spread the information. You know, just, you know, put on our website, here's a list of police officers, check the lists, you know, spread that out maybe onto the court databases so that other attorneys can help share the burden, because at this point, looking backwards at all the cases that might be affected by information that we know about now, we couldn't possibly do it on our own. So if we spread that out and we try to help the defense bar spread the word, while we're spreading the word, we can, you know, find the cases that deserve to be found and any problems rectified because Brady materials weren't turned over.
I was going to not only join in all of Tracey's comments, but start out with, it's not a criminal justice system, it's the criminal justice systems. You got at least 3,000 different separate systems of justice out there, whether it's county, circuit, whatever group you want to do. So focusing right in on the Brady obligations and the Brady. So first, Brady is an obligation. There's absolutely no question about that. The traveling and training that I do, it's always that issue of if in doubt, disclose. And I love the comment here because there's a difference between what you disclose and then ultimately what you may fight about in court. But the best process is to get out there and get in front. But then it becomes a question of how do they do it and what resources are available. Because those that have a very sophisticated information system and case management system, it's very easy for those officers, and there's a couple of very large offices in this country, that once they press the button and that officer is identified, if in fact they're still using that officer, because we can talk about do not call lists here also, but assuming that that officer is in the system and they're going to call the officer, the moment that that subpoena is sent out, the defense is notified, and many of them have an entire packet of information that travels with that case. Here it is. It's passed over and pushed across. So there is that discussion of Brady List. How do you get on the list? How long are you on the list? Can you ever get off the Brady List? And what kind of information do you have? Lots of work with law enforcement agencies. If they discipline an officer, why don't we know? And what was the discipline for? Send over those materials. There are, again, a number of jurisdictions where the chief prosecutor sends a letter to every chief of police, because many of the jurisdictions don't just have one department they're working with. They're working 30, 40. In my world, we had 31 different agencies. So you have 31 different chiefs. Again, it's a fragmented system. Each one of those kings and queens, you got to work with them. We want to know, if you've got a bad officer and you don't tell us, we're not going to accept cases from your department anymore. That's the ultimate prosecutor threat. We won't review it. But as far as that do not call, that is a more commonplace. Does that do enough? I think that's kind of your question, and could you, how far could you go? Even I think some of the discussion of cases today, the prosecutor's office knew of the problem officers, did not use them or talk to them, but did they broadcast to others, look, we think this officer is dirty? And then finally, with Barry, with my California experience, a lot of times it places the prosecutor in a very difficult role, because are we constructively firing that officer? And what does that mean when you as the prosecutor called in front of the personnel board is, why won't you use that officer? You've put him out of business. You've taken her career away. Can you please tell me why? And what's our ethical obligation at that moment?
Eric, you want to?
I will steer clear of the technical, legal, what's Giglio for a second, and I'll just tell you first off, and Wendy, or Tracey alluded to this earlier, which is, we're generally, for most of our counties, and we'll take the Manhattan DA's office to the side, most of us are extremely underfunded and are trying to do what, for example, in our office 10 years ago, we had 1,000 prosecutors. Now we have 700 and some odd prosecutors. So our numbers have gone down 30%. Violence and crime in Chicago has gone up about 160%. The number of police officers has remained roughly the same over that period of time. So you have, and if you look at our post-conviction unit where they're dealing with post-conviction cases, there are probably 300 cases per attorney. We are in a definite triage mode, and while we care tremendously about injustices that occurred under prior administrations, we also need to be manning the wheel, so to speak, to make sure those things are not reoccurring, and have to keep the ship heading in the right direction while at the same time implementing some very significant changes. So all of that in context, Josh talked earlier about the Watts cases, and we actually, in his filing of a motion for a special master, we actually we tried to work with them, and we tried to work with the city of Chicago and the Chicago Police Department to actually, we had picked out folks who were going to do some of the underlying investigation. We had picked out a law professor that was going to help review the cases. I think the rough bill would have been maybe $900,000, $950,000 was what they came back with. And essentially the answer we got from the city, from the Chicago Police Department, from pretty much everyone was, we're not going to pay for it. So we said, okay, well, we will just do it ourselves. And that's what we did, and that's what we have been doing. But I will tell you, when those 15 people charges were dropped, the phones lit up in our office from the city, from the Chicago Police Department, from the Civilian Office of Police Accountability, all saying, what are the names of these officers? How come you didn't tell us anything about this? And you know, it's very frustrating because you're sitting there, I mean, Josh's filings were all public, all of the information is out there, yet, I mean, these officers had been allowed, and this guy was federally indicted. It's not like anyone missed the stories. They knew what was going on, but you do have a number of actors who, you know, let's just assume for a second they're all benign and just trying to get their other stuff done. I'm not saying they are. But it is a hard thing to do, even on a smaller scale, much less going back and dealing with some of the more complex cases, as opposed to the Watts cases, which involved shaking down drug dealers and the like, and were, I will say, they were significant stakes for the criminal justice system, but low stakes in terms of the decision to err on the side of releasing anyone where we were not comfortable with the conviction. So I think it is, we all share the notion of the Brady obligations. It is just, in practice, it can be a very difficult thing to get buy-in. I will tell you, and this is honest to God truth, we tried, there has been no written Giglio or Brady policies in the Cook County State's Attorney's Office. Again, the second largest prosecutor's office in the country, which is, if it's not shocking to you, it should be. And the number, we sat down to talk with the Chicago Police Department about the Giglio questions we intended to ask, and the response we got from some very, very knowledgeable people was, that only applies in federal cases. And I mean, so you are, I mean, the number of times my chief deputy, I can't remember if I mentioned this before, actually was the prosecutor on the John Burge case. And so she was involved very heavily in some of the civil rights investigations at the U.S. Attorney's Office before coming over. But you sit there and you say, oh my God, that we have both a police force that has no understanding or appreciation of what their obligations are. In fact, we were told by the FOP that they would just not answer our questions and not show up to court if we were going to ask those questions of them. But to deal with that, and to deal with a prosecutor's office that has, you know, as Larry mentioned, historically focused on, their job was to put people in jail and to prosecute the cases that showed up in front of them as if it were assembly line and they were kind of making the donuts. And to change that, it's one thing to change it in an office of, you know, 100 or 200 people, but to change it in an office of 700 is, I mean, it takes a while.
I just hear layers to that answer, and what I'm going to try to do is take 2 layers from it, and then I'm going to shift it over to the inspector and get some perspective from law enforcement as opposed to prosecutors. But first, just to kind of go back to what you said a minute ago, Eric, when we talk about Brady right now, we're talking Brady Giglio, and of course, I'm distinguishing when I talk about police officer misconduct. The way I'm looking at it is there's the external Brady information versus the internal. And internal, even though a lot of prosecutors are miserable at it, internal you tend to be a little better because it's information that you have within your case. External is when we're talking about in a personnel file belonging to a police officer. And despite what Kiles versus Whitley tells us, and despite the fact that law enforcement is defined as part of the prosecution team, we do not have easy access to the personnel files. In fact, I've been struck by how much information Mike Mellon and Brad Bridge has about Philadelphia police officers, and I would dare say the vast majority of people in my office don't know even a fraction of what they know. So you have to grapple with that reality as a prosecutor. And oftentimes, the reason why defense lawyers will have more information about a police officer's personnel file is because they'll do what Brad did, which is you subpoena it and you get it. And you get creative. I mean, it was a whole lot more than just doing subpoenas, but you subpoena it. So with that kind of backdrop, I want to try to focus a little bit on what kinds of things can prosecutors do to make the relationship with police a little bit better. So maybe we will get the buy-in from the police so that when we ask for the information that would qualify as police officer misconduct, we'll get it. And so I'm going to turn now to the inspector to tell us a little bit more about how do we get the police to understand that we are responsible for what's in their file. How do we make them realize they have some skin in the game also? Because what we hear is prosecutors who get in trouble for it, but not police officers.
Yes, what we're doing in the IG's office, one of my responsibilities is to make sure we're in compliance. Like I said, when I introduced myself, in addition to waste, fraud, and abuse, a big part of what I do is compliance. And what we did, we developed policy around Giglio and Brady. And what we're going to do, we want to mandate that, starting in the police academy, officers be trained in that case law to let them know what their obligation is. Secondly, what I've done, half of my staff or the members in the IG's office are attorneys. And so what we're doing now in the policy, of course, everything that we promulgate or we write has to go before Judge Bradar, who's overseeing the consent decree. So that's to go in the U.S. District Court for approval. But we've already completed comprehensive policy on both case law. And what we're going to do is conduct an extensive training, in-service training, and we're going to train the police recruits. There's going to be a block of instruction to let them know what their obligations are under both case law. And also it serves two purposes. It lets them know that what they do can come back to haunt them if they're not careful, because for so many years the Baltimore Police Department has been out of compliance with that source of American law. We've ignored it, quite frankly, and we have held officers or retained officers who have had horrific issues with their background in the areas of testimony. And we've had, I don't know the numbers, I don't know, Ian, if we have numbers of officers who were put on the previous do not call list because of their testimony.
Yes, sir, we still have that. And one thing that I think might be different than other agencies, other jurisdictions, we're also putting the onus on the officers themselves. If they know about an investigation that they absorb or an allegation of misconduct that they know about, they have an affirmative duty to tell the prosecutor that morning in court about the new allegation, if there is one. And that's in addition to, on a regular basis, and that's in addition to, all right, that's in addition to, on a regular basis, our internal affairs providing every new misconduct complaint systematically to the prosecutor's office, who will filter those to decide which are going to be disclosed to defense attorneys.
Because there are problems with that, thanks, Ian, there are problems with that. We require them to disclose everything. But, you know, the job inherently puts you in conflict with people, and people make complaints. Many of them are unfounded. That doesn't mean the officer did anything wrong. But many of them have allegations in their internal affairs file. That doesn't mean that they were sustained or they were found to have committed what was alleged. But we still disclose that, and we leave it up to our city attorneys to decipher through that what gets in and what doesn't get in. Excuse me, and it's an entire policy, I mean, very comprehensive. We're very proud of it, and we examine both case law and all the issues, the legal issues in both Giglio and Brady.
Yes.
In practice, I do want to applaud the Baltimore City Police Department. I recently did get a copy from Daniel Beck, who's chief legal, or underneath the solicitor, who couldn't be here today for a scheduling conflict. It's a great policy, and it requires the police officers to self-disclose to the prosecutors anytime they have an allegation for misconduct. In practice, while you're here, and I have your ear, will tell you on the ground the prosecutors aren't enforcing it, and they don't know what it means, and they don't know how to yet. We asked them on the record in court,
issued March 14th. But we can issue, obviously, the state's attorney aren't soliciting it, but the policy itself says whether the prosecutor solicits it or not, you must divulge.
I explained to Major Dombrowski earlier that the police department, well, despite what you might think that we showed, it's been a very trustworthy process in trying to correct a lot of the behaviors of Baltimore. We would just ask you to take an extra step to offer to train the prosecutors on fulfilling your policy in court on the floor.
Yes, ma'am, absolutely.
I'm real curious about that. Let me ask a quick question. I'm curious about the policy. So as I understand it, it's basically just turn over everything, pending or not, sustained or not, correct?
That's correct. Make the prosecutor aware, put the ball in court to make the decision whether they're going to follow up and receive the entire file. For example, if the conduct allegation is that they missed court last week, that's probably going to be discoverable under Brady. But obviously, if there's repetitive FTAs about specific cases, maybe it would be. But that's up for the prosecutor to decide. And I think the other gentleman said, when in doubt, disclose. So we're just trying to put the ball in their court as much as possible. And we're certainly giving what they request on a regular basis, but we're also putting the onus on the officer themselves to let them know about any new case. And they might have got a complaint last night, for all we know. That's not even, it might not be in the IA system yet, but it put the prosecutor's lap to make the decision to disclose or not.
And the timing of that is when an officer shows up pursuant to a subpoena and is going to potentially testify in some sort of hearing, right?
That's correct, ma'am, yes.
Okay. And is there any, I'm fascinated by this, sorry guys, but I mean, yeah, I could just see this, how is there any accountability for that? And it's not surprising to me that prosecutors aren't doing it. So are you required to document that somewhere, that you have indeed disclosed to the prosecutor?
This policy is somewhat new, and this is somewhat new territory for us as an agency, although it shouldn't be, because I think Brady was decided in 1963. So obviously with police misconduct over the past 7 years, especially in Baltimore.
And Girard was 72, so
exactly.
It's been a while too.
Right, and it's federal, it is state, it does apply. We're trying to do something about it. Is the policy perfect? Absolutely not. Our policy's not, but it's a start point. And of course, documentation, follow through, audit, these types of things to make sure it's happening. But the fallback is also every new complaint that IA receives, they give to the prosecutor, and then they filter them.
I know, and as Larry Krasner says every day, don't let perfect be the enemy of good, so you've got to start somewhere. One follow-up to that, and that is, will there be any kind of disciplinary consequences written into that policy if the police officer is not disclosing pursuant?
Right. And that's the next step of this process. Of course, all our policies are being revamped, updated, with the blessing of the court and also with the input of the rank and file and the communities. This is one of them that is a high priority. But yeah, discipline will follow. And not only discipline, the IG's office, once properly staffed, will conduct audits on things just such as this.
Great. Does anybody have anything to add to that?
I was just going to comment that's the reality of the police-prosecutor relations. So often people think that whatever's going on in the police department, of course the prosecutor's office knows. I was just going to state the obvious there is many times one or the other will go in front, and then it's got to be, it takes a little while to back it up and do it. The other piece is, because we've talked so much about crime labs and talking about Brady, I find, and I was just sitting here, Massachusetts, Texas, Oregon, Michigan, California, just a few that I'm thinking about crime lab stuff, is if you go back to 2009 with the NES report about taking the crime labs out of the police departments and the prosecutor's offices, making them their own independents, and coming from a state like Virginia, where the prosecutors there say, hey, it's an independent agency. We can't tell them anything. Therefore, I don't have a Brady obligation. if there's a criminalist that does bad things. You know, that's the lab. It's not me at all. It's a very interesting world right now, and I'm kind of not surprised we're getting the noise that we heard today, because you've caused that separation, and the criminals have never liked us anyway. They see us as I joked here about being finger pointers, just a very, very different. They're scientists, and all we want to do is point the finger, and when they do something that they think might not be that bad. The example we were chatting about earlier, it was a criminalist who was doing the ballistics testing, and instead of firing 10 rounds, fired 6, 7, 8, whatever she needed, collected the rounds, and then went ahead and did the sampling and did the match, and assumed that was good enough, even though the protocol says you must fire 10. And that when finally it got that she was terminated because she kept doing this, why the prosecutor's office got pretty exercised. That, wait a second, she's been testifying in court that she's following and doing the procedure, and yet you knew internally, yeah, but it doesn't matter, that's not material. It's like, there is very much that feeling, yes, we're finger pointers, but when you start lying about things, or the same thing with the court subpoenas, did that person get overtime? And how many times did that person get overtime? And here in Philadelphia, they used to have the little, are the thumb scanners still here? With the law enforcement officers, you got to go to City Hall and press your thumb, and then go up on the court and press your thumb? They're broken. Okay. There we go. But to bring some reality in here, things like that, officers charging time and not showing up to court, there's some truthfulness issues, and then don't we have a Brady obligation? Even though from the outside that agency might say, what's the big deal, it's just internal, so what if it's a little $50 million in overtime? Yeah, it makes a difference in the court. And so those are things that many times shouldn't be overlooked.
So I just have to say, the thing that is alarming to me about those statements, David, is that just means it's a real training, educational problem with prosecutors. Because if a prosecutor is going to go to the extent to get that information from a lab, and they don't believe that they have any kind of Brady obligation because they're an independent lab, but yet they've gotten it, and then it ends up being something that calls into question the scientific validity of the opinion, I mean, you're asking for trouble.
Yeah, and that's where we're kind of at, why we're at. We're headed down that road, because and it was a recent training from your old office where they mentioned, look, we send a notice to the crime lab. If somebody's terminated, we want to know the reason why, just like we would do with the police department. I don't know that that's widespread, and I see the rift because there's the push, the policy reason to get it away from law enforcement. Therefore, it's an independent state agency. Would you ask the same thing of a school department? You know, did they terminate somebody? Would you ask it of sanitation? You wouldn't. Why would you ask the independent crime lab? Why would you get involved in their business? So I'm completely with you. I think it's a dangerous area, and I think today we saw graphically what happens. But as there are policy shifts made, prosecutors do calculate as to whether or not they're on the team.
Any other comments on that? Or we've got a little bit longer, and I've got a couple of other areas that I wanted to jump into. One was, and I don't remember who said this, but they said in regard to the police misconduct and getting the records, verifying that, the comment was made, there is no on or off buttons for integrity. And I think that was said in the context of, you know, if an officer lies once, they're always bad. And so not only do you prospectively get rid of their cases, but you retrospectively get rid of them. And I think this is one of maybe the harder areas for prosecutors, is trying to figure out. I think maybe going forward is easier, but going backwards is not. So can you all give us some of your insight into how you feel about that comment in the context of going back and looking to see if you're actually going to recommend that convictions are vacated?
Yeah, we grapple with that problem with Brad Bridge a lot. Now, there was one police officer who admitted that he perjured himself at trial in order to protect his confidential informant. And so Brad suggested a date, and all cases after that date, the first time the police officer had, or the the case in which he had lied, the date of that arrest, we agreed that if this officer was a critical officer, then that would be the date. Any conviction after that would be the date that we would, it would be those cases after. But now Brad wants us to move the date back, and so it's always, hard to figure out what date, because a lot of times the date is arbitrary, like what date did the officer lack credibility, and so that's, an argument that Brad and I have, and, right now he's asked us to expand that date back to an earlier date, and I'm working with him on that, and we'll discuss it with Patricia and the higher ups in our office. And so, a lot of times Brad wants us to bring things too far back, and, we still have to worry about public safety, and, we just can't let everybody out or reverse every conviction. So it's difficult to try to figure out what would be a fair date to, us and public safety, and a fair date to defendants who have been convicted. So that's always a work in progress.
Yeah, two things. First, we do it on a case-by-case basis. So we do not, it is very difficult to say, okay, how many cases did this officer touch, and it's very difficult for us to figure that out, much less how many cases did they touch in a substantive way. Again, to put some perspective on it, we're handling probably 150,000 felony cases a year and close to 450,000 misdemeanor cases a year. And in the misdemeanor cases, we have no misdemeanor case management system. So all of that is done on paper, literally written in the folders, and the folders get filed away, and there's a document retention policy. So in many cases, it would be physically impossible to do it for a lot of the cases. So we do rely on issues in many instances being brought to us. There's some cases where Detective Guevara has come up where they're more significant cases. He was a detective who did a lot of murders and homicides, so it is easier for us to look at the universe of those cases and try to figure it out. I want to just address one thing, because it struck me as relevant that the gentleman there had raised earlier, which is this question of, is there a higher proportion of police officers that do criminal things than other professions? I don't honestly think so. I think that there is a lot of publicity, as there should be, and a lot of attention paid when those police officers do violate the law or do something, and so there's a lot of focus on that. But again, you're talking about, in Chicago, you're talking about 13,000 police officers. You're talking about a very, very small percentage. And to the extent that a larger percentage of the police officers are involved, they are involved because they are not going to their superiors and reporting those officers and reporting the misconduct. And I will tell you, and maybe everyone else, but, that's a very hard thing to break anywhere. We had a situation in the prosecutor's office where there was, someone did something that was, beyond not appropriate and probably not legal, and there was this sense of, well, he's our friend, and we're not gonna, to really explain to everyone in the prosecutor's office, no, that's not how we roll. We don't work at Walmart, we work at the prosecutor's office, and certain things are expected of us, and we do have a higher obligation, and we do, and you can't, again, no one is perfect, but we expect a much higher standard. And those are, going back to what Larry said, those are cultural shifts that will get made over time, but they're not easy things to do, even in an office of, well-intentioned and well-trained or schooled individuals.
one last question, and then we'll open it up if anybody has any questions. But Barry asked during his panel, it was during the discussion about crowdsourcing and all the different things the various different public defenders were doing to, get the data and assimilate it and figure out what it means. And Barry specifically said, is that type of crowdsourcing, is it something that's going to change the behavior of prosecutors? And I had an immediate reaction to that, but I'm curious as to what you all thought of that. Do you think that it will, what we're seeing that the defenders are doing?
I think it does. I think each side, the more active one side is, the other side has got to figure out to react, or what are they getting, how do they have that information, and I don't. So I think there is that sort of natural reaction to it. Public defenders, and I think it was San Diego, they created credit Brady thing. They went and pulled a bunch of records, things like divorce records and transcripts, and then the police union sued there, saying, wait, you're invading the privacy. So there may be a certain line as far as collective information, but why not? It's all public record. If I know sometimes after I interview somebody, I go to their Facebook page, I look at their tweets. I like to, I can't believe sometimes they'll talk about, after a meeting with you, they tweet some really inappropriate stuff. Why not? It's out there publicly, and when you're thinking, and on Eric's point, working in a prosecutor's office, or what I say on behalf of the association, if you work for me, do we want to pick up, and I'm still one of those guys, I still get my post and I still get it in paper. I'm keeping the paper folks going. Do I want to be above the fold? If I want to be above the fold, let's do it. If I don't want to be above the fold, we're not going to do it. And that's always that concept when I ran the office and dealt day to day. Can you explain it to a grand jury? Because obviously, there's Barry laughing, you're in front of the grand jury, so something did not work. But did you have all of the information in front of you, and did you make a smart decision? Or did you make a snap decision that obviously now has done really poorly? That's what we always need to be thinking about, and that's what I think at the staffing level and all those involved, especially things like Brady, why didn't you disclose? You better have a really good reason. And if not, again, if in doubt, disclose.
I'm not that optimistic. Go ahead.
I don't know if I have anything else to add. I like what Mr. Scheck said earlier, and maybe this is a little off the subject, but when you talk about police misconduct, especially potential court testimony, you have to nip it in the bud, even the smallest of things. It's been my experience, when you don't address the small things, it sends a clear message that it's okay to lie. And then the lies exponentially get worse depending on where you are. And then I would argue too that, to your point, that in America, I think we have 18,000 local and state police departments, county sheriffs in America, and almost a 250,000 police officers. That's not counting the feds. This is just state, local, county sheriffs. And imagine with all the horrific things, the gun trace task force in Baltimore, and the many other acts of police misconduct and integrity issues, they still represent just a microcosm of the profession. We want what most occupations want. We want integrity. I don't know too many officers or cops, if you will, that enjoy serving alongside officers who engage in some of the activity that we've seen. Is it a problem? Absolutely. It's a problem in underserved communities. Ian and I talked about the need to take these young officers out of some of these distressed neighborhoods where they investigate drugs and guns, because many of them psychologically identify with the very element that they are investigating if we're not careful. So we victimize them, we leave them out there for 7 and 8 years, and then wonder why they start thinking in terms of antisocial behavior, because that becomes their world. I know Jenkins was virtually his entire career, Sergeant Jenkins that we saw on the board earlier, he was there virtually his entire career. He worked drugs and guns. His entire career, 10 years, he dealt with the underworld. And so why are we surprised that psychologically, even sociologically, he took on the character of the very people that he spent probably 10, 12 hours a day with?
Anybody else? Anybody have any questions from the audience?
Student a rough count of the group exonerations we would know about. Over half, including, if I'm not mistaken, the three that are represented here from Baltimore, Chicago, the group exonerations from Baltimore, Chicago, and Philadelphia, which account for the great majority of the individuals that are exonerated in these cases, originated in federal investigations of corrupt practices by local police. My question is simply, do you think local and state prosecutors ought to be doing more of that?
Jeez.
There you go.
I'll take it because I've been on both sides. It is, even with the resources, it is very difficult to do an investigation of that type of an investigation where it requires really covert work and the like. That's a tough thing to expect a prosecutor's office that is working with the police on a daily basis to do. I think it's easier for an attorney general or for a U.S. attorney's office to do. I can tell you that even in situations where you're dealing with police officers who engage, I mean, we have 2 police officers who are prosecuting for first-degree murder, and those cases are extremely difficult to put together in terms of the cooperation you need from law enforcement, and the fact that, I mean, the reality is you still need to work with these officers, the majority of whom are not involved in improper conduct on a daily basis. But just from my experience in the U.S. Attorney's Office, I think they are much better situated to do those. I think there are certainly, I mean, we have a professional standards group in our office. They do mostly police shooting or serious, more of it is violence than the kind of scale corruption that we're seeing here. But you already have, and I don't know how it's working in Philly, but you already have, as you can hear from the comments I read from the FOP, you already have a tremendous amount of distrust. And look, I mean, we have to balance it in terms of, on the one hand, you know, you want to go in there and you want to clean everything up. On the other hand, you can't throw out the baby with the bathwater, because this is a very complicated system that you do rely on the majority of honest officers. So it's just a tough tension, but I do think the feds are in a better position to do it.
And State's Attorneys General?
Well, I was going to say, it all depends on the resource issue. Being a prosecutor from the West Coast, we had our own Bureau of Investigation. So independently, we could go out and investigate cases. We could take over scenes. Larry mentioned George Gascon, and you know, his work in San Francisco is go in and be able to do work on behalf of the prosecutor's office. We're in fact having a roundtable next month on this, because as you move east, most offices rely on the police departments. So the prosecutor doesn't have any independence. So you want to go in and look at the corruption, who are you going to send? And then that's why logically, yes, attorneys general, if they have the capacity or resources, or obviously the feds. But having come from an office that had a good department and bureau, and it was a narcotics case that I personally touched and handled, we figured out who would be a good undercover and sent an undercover in from another city, so the department had no idea, and a total hush-hush. Sure enough, the detective did just exactly what the community was saying he was doing, and that was the end of the case. And it was a very easy state case where I agree a little bit about, you know, you work with them, can you really prosecute them? I also say on the other hand, most especially really good cops, they don't like the bad cops, and especially if that one, because they've got a reputation within the department, and that's why I'm looking at my friend here. And when you go ahead and prosecute them, it's not a problem, especially, you know, for stuff like the theft and stealing. The use of force, I'm going to back up Eric, that's a really, really complicated one. Because at the same point, if it were my loved one that were killed, I don't know that I'd want an AG coming in or a U.S. attorney trying to try that local homicide case I'd rather have the homicide prosecutor from that jurisdiction who understands the jury, who's really good with juries, try to do it, because those are the most difficult cases out there. And as everybody well knows, right now there are not many offices that are able to return those verdicts. We used to laugh that if we get a DUI, the AG will prosecute. You're going to walk anyway. Don't worry about it. So there's a real difference on who are the very best lawyers to try a complicated murder case in any particular city.
Well, I think one of the things we have to discuss too is the politics of it. I know in Baltimore, I can share this with the Baltimore 6 that prompted the riots for Freddie Gray. There's a strained relationship between our fraternal order police and the prosecutor's office, because many perception or reality, sometimes perception becomes many people's reality, that the prosecutor prosecuted those officers for political purposes. I'm not saying that. I know this is taped. I'm not saying that, but this is the perception. It's the perception that the prosecution of those Baltimore 6 was motivated by politics, and that the prosecutor pandered to public opinion. And so I think that it's situational, but an unintended consequence, could be a work slowdown, or officers. Now that we have the body-worn cameras, we see the hesitancy sometimes in our members to take action, because they don't know even if they make a mistake, many of them are fearful that their names can end up on the prosecutor's desk. So that's something that has to be considered.
And I hate to do this because this is a conversation that's important and could go on, but we've reached the end of our time. So I want to thank this panel very much.